We're a couple minutes over, so I think we can get started. Good morning, ladies and gentlemen. Welcome to our webinar, How to Think Like a Lawyer, a Practical Guide to Managing Risk. This presentation, this webinar is created in conjunction with the New York State AIA Education Committee, who was instrumental in putting this presentation, as well as several others, together. So I thank Mike Coca and your staff for doing such a great job. Today, my name is Dave Kosikoff. I'll give you a little bit more information about myself in a minute. And I am joined today by Stephanie Reda, also an attorney, who is the claims supervisor for Everest National Insurance Company. They are one of the leading insurers of design professionals in the nation. Our program will run for approximately 90 minutes with time for your questions and answers, hopefully. Before we begin, I just want to address a few housekeeping items for you. First of all, this presentation is sponsored by Everest National. So I want to thank Stephanie and Everest for their support and appreciate their contributions to the architecture community. The presentation has been approved for 1.5 learning units. To receive the credits, you must be present for the entire session. Throughout the program, you will see 4 words that appear in the chat box, and they'll also appear on screen at various times. Please take note of these words as you see them, because you will be required to write them on your CE card link that will be provided in the chat box at the conclusion of the program. This card must be filled out and returned to us no later than tonight at midnight. Again, please be sure to open your chat box to see these words and the CE card link. We encourage your questions throughout the session. If you have any questions for us, use the chat box at the bottom of your screen. If you are having any technical issues or have a question about the webinar itself, use the chat box and we'll do our best to answer you during the webinar. As a reminder, as I said earlier, please keep your microphones muted and cameras off for the entirety of the program. Utilize the chat box feature to ask any questions that you may have. See, when lawyers get involved, you have these disclaimers, so very apropos of this presentation. Our disclaimer slide: this webinar and associated materials are being provided for general educational purposes only. Information provided during this webinar and in the materials should not be construed as professional advice. Participants should consult with a licensed architect or other appropriate professionals concerning the subject matter of this webinar, the materials, and their application to any specific facts or circumstances. The statements of the webinar moderator and panelists are their own and are not statements of the AIA New York State. We ask that you read the other disclaimers just so that you know what to expect. But today's learning objectives, you can see them on the slide, so you can do a quick review of those. And so now, this is one of those 4 words that I told you about if you want your learning units credit. And the first word is proposal. So please make sure that you write that on your card. Now, moving along to the main theme of today's presentation, and before I cite to the Code of Hammurabi, I'd just like to tell you a little bit about the people that you'll be staring at for the next hour and a half. My name is Dave Kosikoff. Many of you know me from prior presentations. I am the managing partner of Kosikoff and Cataldo. We're an 11-lawyer firm whose emphasis is on addressing the needs of architects throughout the state. Clients in New York typically have the ability to request counsel of their choosing to represent them in the event that they find themselves in a lawsuit, provided the insurance company is comfortable with the requested lawyer and that lawyer has the requisite experience to provide a requisite effective counsel for design professional claims. My firm works with more than 20 professional liability carriers, and the carriers generally accept the request for representation by my firm. I am General Counsel to the Westchester-Hudson Valley Chapter of the AIA. So to the extent that any of you from my chapter are here today, a special shout out to you and to your chapter's Executive Director, Valerie Brown. Today, I have the honor of being joined by Stephanie Reda. Stephanie is the head of claims for Everest Insurance Company. As I said earlier, they are one of the leading professional liability carriers in the country, as well as the sponsor of this presentation. Stephanie, I'll turn it over to you and you can provide an introduction for yourself.
Sure, thank you, David. I'm honored to be speaking with you today. As David said, I'm the professional liability claims supervisor for Everest Insurance. In this role, I'm tasked with overseeing all of the architects and engineers' claims. For those of you that may not be familiar with us, Everest A&E is quickly becoming a go-to market for design professionals and their brokers. Our goals are to be focused on quick service, thoughtful responses, and tailored solutions for our insureds. Also, Everest A&E just recently introduced our new Everest Elevation Architects and Engineers Professional Liability Policy. The policy now provides state-of-the-art market enhancements, including built-in pollution and cyber coverages. For myself personally, I joined Everest approximately 4 years ago. Prior to that, I practiced in New York in the areas of construction and design litigation. I'm certainly the person that no insured ever wants to have to speak to because it means they have a claim come in the door. But I make it my goal to make sure that the claims process is easy to understand and as seamless as possible for our design professional insureds. And I'm very excited to be speaking to you all today.
Thanks, Stephanie. And I will tell you that if you do have a claim, she's actually very easy to talk to. So you'd be lucky to have her.
Thank you.
So how to think like a lawyer? You may ask yourself, why would anyone want to think like a lawyer? After all, the legal profession is the butt of more jokes than any other profession. Lawyers are reviled for perceived self-interest and billing clients for anything they can. But of course, your lawyer is the first person you call when you're in trouble, the first line of defense against an unscrupulous owner or contractor. So why would you want to think like a lawyer? Well, because just maybe you could avoid or minimize a problem before it goes off the rails. Because just maybe, if you think like a lawyer, you can avoid calling a lawyer. Because if you don't think like a lawyer, you may find yourself in a heap of trouble. So let's get right to the main theme of our presentation. And as you can see, the first slide that we have here is the Code of Hammurabi. And I like to quote from this slide to give you some perspective. Back in the day, it just shows you that construction and design issues have been going on for quite a long time. And back in the day, the consequences for a poor design or construction were pretty dire. And you can just, and I won't read the whole slide, but you can see from the first quote, if a builder build a house for someone and does not construct it properly, and the house which he built fall in and kill its owner, then that builder shall be put to death. Wow. If it kill the son of the owner, the son of the builder shall be put to death. Fortunately for all of you, today, the consequences are not nearly as dire. Basically, what typically happens is if there's a lawsuit, it's generally about how much money the claimant can recover. And for those of you who are wise enough to procure insurance, the dollars come from the pool maintained by the insurance companies. The good news for today's presentation is that the ultimate outcome of a resolution will be far more palatable than the days of Babylon. Moving along to the next slide. So we put this slide into the presentation because it's actually very apropos for construction disputes. It's from a famous case, the C.J. Coakley Company versus Blake Construction. And the judge in that case noted that except in the middle of the battlefield, nowhere must men coordinate the movement of other men and materials in the midst of such chaos and with such limited certainty of present facts and future occurrences as in a huge construction project. And no truer words were spoken. On the next slide. So we're gonna go over this just briefly. Typically, when you're first involved in a project, everybody's in la-la land. It's the honeymoon period, the dating game, as we like to call it, where everybody's getting along and your clients are excited about some unique design that you're going to provide. And so this is the most wonderful time of the whole project at least until the end, and hopefully everything goes well. But this is the time when you really want to make sure that you protect your interests. Going along to the next slide. So one of the things that Stephanie and I are going to try to do today is actually give you examples of things that you should be mindful of during all aspects of a project. And so selling yourself, I'm going to recount a very short story, but it's a real story of a client of mine who had promotional materials where they cited themselves as the greatest architect who could do the finest work in the land. And I'm only exaggerating a little when I say this, but what that client, what that architect wound up doing without even realizing it, is that they were increasing the standard of care from what every architect does to the finest of architects, because they were saying that they do what no one else can do. So it's one thing to have, like this presentation is a marketing opportunity in some sense. So are your webinars, and so are your websites, and so are your written materials, and anything that you might do. So you have to be mindful that you don't want to oversell yourself when you're trying to promote your firm. Because in the very real case that I've just described, where my client had marketing materials that were over the top, they really created for themselves unwittingly a situation where they elevated the standard of care. And that's not something that you want to do. Let's go on to the next slide. So when you're dealing with clients and you're presenting options, and you know, for those of you who are on a prior presentation that I gave know that contracts is an entirely different presentation that could last for hours. But just to remind you, you want to make sure you have contracts. You want to be mindful of the type of contracts that you use. If you use very involved, 47-page contracts, you're going to invite attorneys to start looking at them, and you want to be careful. And proposals, many of you use proposals, which is fine, but you want to make sure ultimately, by the time you sign up your client, that you have a written agreement. Let's go to the next slide. And while there is no actual rule or law that says it, we strongly urge you to have a signed agreement before you start work. One of the things that you should look out for is that sometimes a client's ready to get you moving, but they haven't signed the agreement. And sometimes there's a reason for it. They might be avoiding doing that. So you want to be sure that you have a written agreement that's signed before you start your work. Moving along to the next slide. And I'm just going to take you through this very quickly as to the perils of not having a contract. By having a contract, and a contract that clearly defines your responsibilities, including, for example, that you're not responsible for construction activities, such as, and these are things that should be in your contract, means and methods of construction and site safety. These are issues that are critical. And for those of you who haven't already gotten a copy, I've prepared a standard terms and conditions that I did in conjunction with one of the former presidents of the Westchester Chapter, Dennis Noskin. For those of you who don't have that, you're welcome to email me and I'll provide you with a copy of the standard terms and conditions. But you really should have very carefully worded contract language that helps you to define your role. For without that, with it, you'll be the smiley face on the left. Without it, you'll be that frown on the right. So this is just an illustration of what it means to have a written agreement. Moving along to the next slide. All right, so understanding the owner's objectives. An owner would like as much as they possibly can get for the least price possible. But the fact is that the elements of every project are directly linked together. So for example, if an owner establishes a price, but they want to enhance the quality, they're going to have to compromise in one of these areas. So if you're going to stay steady on the price and you want to increase the quality, well, you're going to have to decrease the size. If you want to increase the size of the house, then you're going to have to compromise on either quality or price. And you'll see that each one of these areas is really interrelated to each other. And so you have to be mindful of your client's desires and their overall interest, which is very typical of monitoring and maintaining a price point, and let them know that with every decision that they make, they are going to impact one of these other or both other areas. So that's really up to you to keep your client informed. And for those of you who have heard me speak in the past, you want to be certain to educate your clients, because your clients, many of them are first-time users of Architect, and they may not understand that. And also, and actually, I got in that chat room, somebody else reminded me that time also is a factor that impacts a project, both in terms of the owner's interest and in terms of the cost. The longer you go, the more time is going to impact. So thank you for that comment by one of our listeners. Moving along. So Stephanie and I can both tell you that dollars often drive claims. Most clients are interested, as I said earlier, in maintaining cost. Some of the information that you include in your contracts can very possibly impact the bottom line and impact your relationship with the owner. The owner will give you a budget. You have to be mindful of what the budget is. The AIA contracts, many of them call for a fixed limit of construction and have various consequences if you don't fit into a certain cost. True story. A client had a price point that they communicated to the architect. The architect prepared a set of plans, and ultimately, when they went out to bid the job, the set of plans came in for twice the cost. Now, obviously, that's a big miss. And even though the AIA contract indicates that architects are not responsible for the costs and they don't have the expertise to evaluate costs, I submit to you that notwithstanding that language, if you miss by that much, you're going to create a problem and you may face exposure. Some of you may be wise to recommend to a client that they can get cost estimates to gauge the cost of a project before you proceed much further, so that if you have to, you can modify your design. But you really should include in your contract language an indication that if you're going to have to modify the drawings, that would represent an additional service. But just to recap this particular slide, dollars drive claims. People don't like to spend more money than they expected, and novice owners will certainly feel the pinch, and they'll come back and hit you hard if they have to pay more than they expected, I guarantee you. Moving along to the next slide. So now, what happens that would impact cost? So here are three areas that could impact costs. Having to redesign, that could impact cost, particularly if you're charging that as an additional service. Changes are an area that clients don't really seem to understand the cost impacts. So clients, once they see your design, they may come up with other areas or other options that they want to insert. And these are the type of options that could have an impact on costs. So you have to be very careful about that as well. Stephanie, I know you wanted to talk about factors that impact client expectations as well.
Sure, this is an example, fits right into the topic of both client expectations and changes. I'm currently handling a claim involving a very high-end private home. It was a new build. The construction was originally estimated at $5 to $6 million. The homeowner herself has taken it upon herself to insert into every step of the design and construction phases, right? Being present at the meetings, showing up at the job site on a daily basis. They have no construction or design background. I should mention that. The homeowner has requested a multitude of changes along the way, expanding rooms, moving walls, adding an elevator where there was a staircase. The homeowner mysteriously cannot understand now why the project has required extensive redesign, why it's taking years longer than originally planned, and most importantly, why it's costing more than was originally budgeted. She's now attempting to blame the architect, right? Saying that the architect never disclosed these items to her. The architect's design as originally made had errors in it. Meanwhile, our architect insured is really just trying to accommodate this very demanding client's multiple requests. We're now tasked with defending this claim. We're trying to build the record of how the changes requested by the owner have impacted the critical path of construction, how her changes have impacted and necessitated multiple redesigns. And what we're doing is building a timeline of events and to indicate and to establish that there is zero evidence of architect negligence. This is really just an example of how the owner's tastes have changed and how their requests for redesigns have really impacted this project in a meaningful way. So I think that that's a pretty good example. I can't say how it could have been prevented. They certainly have a written agreement here, but sometimes the client is really just creating a lot of the problems. I'm sure you could agree with that, David.
Stephanie, I've had a number of claims and where I had homeowners, both husband and wife, and one is tasked with the responsibility for the development of the project, and the other is a sort of the money person. And they don't always communicate with each other. So in one instance, one of the spouses will do the changes that I talked about earlier and increase substantially the cost of the project. And when they start getting the bills, the other spouse who is responsible for the bills is shocked. Mm-hmm. And so sometimes on the client side, you get a lack of communication. The other thing that I've seen that has a significant impact on a price, on the cost of the project is latent or hidden conditions. I have a project right now where my client is involved in a renovation in addition to an existing structure, and you really don't know what's behind the walls. And invariably, it comes from years of deferred maintenance or simply things that you just have no idea about. And as soon as you open the walls to conditions that you're not aware of, you can bet your bottom dollar that between poor electrical wiring or structural deficiencies, that latent conditions can have a meaningful impact on the cost. It's one of the reasons why our clients would be well advised to have a significant contingency for latent conditions, because they're going to incur those costs for sure. And one of the people in the chat room, and I thank you for the comment, it's spot on, indicated also that in the time of COVID, what we have seen is the material costs have exponentially increased. And so that's another item that, now that we always learn from new circumstances. And one of the things that you might be mindful of is indicate that under times such as pandemics and so forth, you may see increase in pricing for materials. And by the way, I can tell you also that since construction is really receiving a boom right now, some people that I've talked to who are looking to do projects are talking about how construction costs have increased exponentially. So that's very important for you guys to keep in mind. So moving along to the next slide. And by the way, and I appreciate the comments that we're getting from some of our listeners about regulatory controls or increasing costs. And here someone indicated that plywood doubled substantially. So you're seeing significant increases in costs as a result of the pandemic. Events during the project. So, it's unanticipated issues are going to happen at every turn. You go to project meetings and issues are going to come up. And these are all things that are going to impact costs. Increases in scope of services. You all of a sudden may be called upon to do a much more thorough investigation than you ever originally anticipated. So this is going to increase the scope of your services. You should very clearly define what your additional services are, because when you start billing for these additional services, your client's not going to be happy. It's going to be an increase in cost. And ultimately, that's going to be an issue between you and your client. So you want to be mindful of things like that. And, you know, as I said, putting the additional services in a contract is really essential in terms of additional scope when you go to a job. And finger pointing. Well, what do we mean by finger pointing? There always seems to come a point during a project where something goes wrong. I hope that's not the case, but it does happen. And ultimately, it winds up becoming an issue of, well, who's responsible? Is it the design professional or is it the contractor? One of the things I will tell you is that for savvy contractors who are looking to increase their ultimate profit margin by submitting change orders, if they see a problem with your drawings, it's not unusual for them to seize upon that opportunity to add a cost through a change order for additional costs based upon what they might say is something that they didn't expect. So right now I'm holding up a book. I'm not advertising the book, but it is actually a book, Contractor's Guide to Change Orders. And it is actually the playbook for contractors to seek additional costs through change orders when they sense that there's either a problem during the course of a project or there's a weakness in the drawing. And for those architects, and I assume almost all of you are architects who don't know, there is no such thing as a perfect drawing. So there's bound to be a vulnerability in your design services that could come up. And a smart contractor is going to take advantage of that. Anyway, moving along. So if it's not in writing, it never happened. Now, Stephanie and I didn't make up this statement, but it really has become a common axiom that you should be mindful of. So what happens during the course of a project, you should be very thoughtful about documenting issues that come up, because one day down the road, when the finger pointing elevates to a point of either a claim or nasty letters or so forth, but if you document things that happen at the time that they happen, you'll be in a much better position to identify those issues and confirm what happened at the time that it happened, rather than trying to cobble together a story 3 years later when you're in a lawsuit and Stephanie and I are assisting you. Stephanie, I know you have something to add on this topic. You're on mute, Stephanie. Stephanie, I don't know if you can hear me. You're muted.
Can you hear me now?
Yeah, go ahead.
Sorry, thank you. So we have a very new claim for our insured architect, just came in last month. Came in as a demand for additional costs related to roof snow guards on a commercial building. And the claim is that the insured was negligent for not including these in the original design. The owner's claim was prompted after a severe snowstorm this winter and an allegation that there was damage to the building as a result of not having these snow guards on the roof. When I spoke to the insured, he assures me, well, in fact, we recommended these snow guards. We included them in a proposed design. It was the owner that decided not to go forward with these. He didn't want to incorporate them in the final design because for cost savings, right? These roof guards were going to cost them an extra $100,000 for this project. Problem is, when I asked the insured, where are the records? What do you know? All these discussions are verbal. At project meetings, there's no record of these conversations taking place. There's no emails confirming that this was recommended and decided not to go forward by the owner. And as David said, and as I counseled this particular insured, without the documentation, this is really going to become a true he said, she said that is going to have to play out as the dispute is litigated. You know, I think looking back, I'm sure this insured wishes he would have either put this in a project meeting or at a bare minimum, you confirmed it in writing somehow via email. Even email is not a contract, but it's at least some evidence. Right now we have nothing. So we're just gonna have to see how this plays out as it goes on.
You know, it's an excellent point, Stephanie. So emails are the way of the land these days. And there's nothing wrong with, after you go to a project meeting, to memorialize the conversation in an email, and it doesn't have to be some type of a legal treatise. It could simply be, hey, Bob and Sue, it was really great seeing you earlier today at the site. Just to recap what happened at the meeting, and you put it down. And one day, when, to use Stephanie's example, when someone says, you never told me, well, that's your way of documenting what happened. It's a perfectly legitimate way. It's something that happens contemporaneously with the event. And now that sounds like a lawyer speak, but it is. It's far more credible to pull out an email at the time that something happened than 3 or 4 years later when you're knocking heads together in court and someone says, no, he never told me. And you pull out the email and you show that it was sent and that what you said, it is such a better way of protecting your interests. But by the way, it's not just a question of protecting your interests. It's to clarify a conversation so that there's no confusion. Because just like the old game of telephone, where two people could be involved in a conversation, and one person hears one thing and one hears another, that's really an issue. Wait, I have a question here. Are written notes legal? Yes, they are. As long as you can prove that they are part of your regular business documentation, they absolutely are. One of the things that you can do, aside from sending an email, is you can actually draft a memo and keep it in your own file. And as long as you can demonstrate that that memo was prepared in the ordinary course of business, here again, another legal terminology, but it would be admissible in court. So good question, and yes, your notes are helpful and they are credible. Next slide. So we talked earlier about what happens at a project meeting where you have meetings between owner and contractor and architect. Now, each party to the construction project has their own perspective. And so we're going to talk about their perspective in a moment. Let's go to the next slide. Okay, here's your next CE word number 2. It's redesigns. So please note the word redesigns on your card to get full credit for this presentation. All right, everybody take note, and it should be in the chat room as well. And there's Molly is putting it in the chat room. So please remember that. So now we go to, we're going to talk about each party's perspective. Let's start with the owner's perspective. Let's go to the next slide. So the owner. So we've talked about this. Owners don't like changes, but they cause changes very often, and changes are going to impact cost. And whenever you impact cost, you're going to get into a situation where you might blame somebody. It's an interesting thing that happens during the course of a project. The dynamics sometimes shift. And what do I mean by that? Well, at the very beginning, you remember we talked about the honeymoon period, where the owner and the architect are getting along swimmingly as you're creating, say, the owner's dream house if it's a residence. Everything's great. The architect becomes the essential link between the owner and project completion. But there does come a point in time when, during the course of construction, the party that becomes more of the essential link to project completion becomes the contractor. The contractor is the one with the hammer and the nails, and the architect becomes sort of very secondary. And sometimes, and I've seen this happen, the contractor has the ability to grab the ear of the owner, and as the contractor is seeking additional costs through changes, the owner is getting upset, but not always with the contractor, sometimes with the architect. And you might see this manifest itself when you start issuing bills and you're not getting paid. And the owner tends to identify issues that you may have done wrong. And by the way, they're bound to find some issues that you may have done wrong. And suddenly you feel vulnerable and you start accepting a delay in payment, which is a very dangerous thing to do because it becomes a slippery slope. And when I talk about loss of profit in this slide, that manifests itself in a couple of different ways. for those who are dealing with commercial owners who might be losing profits because the project gets delayed or has a problem. This can be an issue. And your own loss of profits could happen because an owner stops issuing payment. So this becomes a very sensitive time period. And by the way, and we'll talk about this a little bit later when we talk about pre-claim assistance, but sometimes this becomes a time of significant vulnerability that may require you to seek some guidance. But as I said, I'll table the pre-claim assistance for a few minutes. And just one last word on loss of profit. So I talked about contracts and contract language. And one of the things that you might be mindful of is inserting a waiver of consequential damages. So what is a waiver of consequential damages? Well, particularly when you're dealing with commercial owners who might be looking to start their restaurant or department store or some such thing where they can receive profits once it's open, they might try to blame you for their lost profits, which could significantly increase their potential losses. So a waiver of consequential damages is a way of protecting yourself from what could be a very significant element of damage. So keep that in mind in your standard terms and conditions. I know that most of the AIA forms of agreement include waiver of consequential damages. So that's a big contract provision that I strongly urge each one of you to include. There are other areas that you could include also, including what some of you have heard me talk about in the past, which is a limitation of liability. And I could probably drone on for half an hour about that also, but that's a clause that I would encourage you to insert as well. Moving along to the next slide. So the contractor's perspective. Well, I'm not suggesting for a moment that all contractors are not reputable. In fact, I suspect that many of them are reputable, but many of them, as I said earlier, have the ability to justify a claim for additional fees in the form of change orders. The shop drawing process, for example, is an area where the contractor could try to shift blame to the design professional, sometimes by inundating them with multiple shop drawings at a single, at one time, making it difficult for the architect to present shop drawings, to review shop drawings in a timely basis, which could lead to delays in a project, which may serve as the basis for a contractor to seek additional costs. Again, as I mentioned earlier, there are times when the dynamics change and the contractor becomes the most important part of a project, and they get the sympathy of the owner. And this is an issue that happens during the course of a project. Change orders contractors are infamous for asking for change orders for any such thing. And frankly, as the architect, when justified, you have to defend your design and defend the owner against change orders when there are areas that are included in the contract documents and the contractor just fails to identify them. One of the areas that can best serve your purpose and the benefit the owner is by including in general notes as many specific issues that are required of the contractor as are appropriate. So that's an area that really is something that you could use in the general notes to protect your client. And delays. I alluded to delays in the shop drawing process. There are any number of reasons for delays. Of course, COVID is a reason for delay. And really, there are issues that are outside the control of any party. The old force majeure clauses don't necessarily serve to benefit any party in terms of COVID and the pandemic. So even when drafting your own contracts, you should be mindful of new language that could help to protect your interests. Delays are really the single most area that could drive costs on any construction project. And moving along to the next slide. Well, and here's the architect's perspective. And since many of you are architects, you should be mindful of ways that you can protect your interests. I'm going to ask Stephanie in a moment to address the pre-claim assistance, but payment issues are where you're going to find that owners are seeking to shift responsibility and perhaps fault architects for problems. And this is where you might get some nasty letters or simply the owner starting to blame you. And when you sense that there's a problem where a claim might be around the corner, there is a program that many carriers employ. It's called a pre-claim assistance program. And I believe that Everest has such a program. So I will allow Stephanie to discuss how Everest addresses pre-claim assistance.
Thanks, David. So the Everest policy does provide multiple forms of pre-claim assistance. So I'll use that in a broad term. I'd like to highlight a few. We have what we would call traditional pre-claims assistance. That's exactly what David's talking about here. You know, the insured is involved in a project, some issues start to arise. Maybe there seems to be some disputes between either design professionals on the project or most often the case between the owner, the contractor, and the insured gets what I like to call, you know, suspicion. There may be some finger pointing. As David also alluded, these are most often related to increased costs or delays, or, you know, maybe there's just general discontent on the project. The project has taken longer, parties' interests have changed in the project. So in these cases, when the insured puts us on notice of these situations, we assist them. We prepare them for meetings with the owner contractor team. We will ghostwrite and draft responses to requests for information. And perhaps, depending on the circumstance, we retain counsel if warranted to assist the insured in navigating these issues. These expenses are paid by Everest. They're outside the policy limits. And what we're really trying to do is avoid having a claim raised against the insured down the line. Another form that we see a lot, and this is usually when the project is already completed, it would be a records demand. And it often comes in as a formal subpoena, right? So the insured's not a party to the dispute, but maybe the owner and the contractor have gotten into a dispute either as the project is nearing completion or perhaps after it is, most often over payment. As you know, I think you're sensing a general theme here. And either the owner or the contractor or others have requested records, information, testimony from the architect. You know, the request could be benign. It could really be a means for one party to gain information to use against the other party in the dispute. However, what do we always have to be cautious of, right? The requesting party could have an ulterior motive or goal. They might want to gain information from the architect to build a case against them, right? Maybe the contractor in their dispute with the owner is saying, it wasn't me, it was the architect. It was the architect's changes. That's why we have all these change orders. So in these cases, you know, we assign counsel to assist the insured in responding to the requests, in producing records, or even appearing at the depositions to make sure that the architect's interests are protected and they're not revealing anything that could be used against them down the line. Our newest policy form also offers what we call rectification coverage. This is when a project is still ongoing. And although a claim has not yet been made against the insured, either the insured notices or someone on the project puts them on notice of a design defect. And if this design error or omission goes unresolved, it could result in a claim being made down the line. So in these instances, the insured would put us on notice of this discovery and their intent and plan, including proposed cost, to remediate the defect. We would then review this, give consent for the remediation efforts, and subject to the sublimit that's on the policy, the cost incurred by the insured would then be, you know, covered by the policy. Again, the point being, let's mitigate the issue sooner rather than later, rather than having a known issue go unattended and then develop into something larger down the line, potentially impact, you know, the critical path of construction. We want to get out ahead of it. So we certainly encourage our insureds to take advantage of all these options. We recognize that it saves both the insured as well as us time and potentially money to be prepared, to be proactive, and to rectify the issues as early as possible.
Stephanie, I just want to ask, in terms of the Everest policy on pre-claim assistance, what impact, if any, does it have on their loss history?
So I will give my standard lawyer answer here that I'm certainly not the underwriter, but it does show up as a potential claim. And what is standard during renewal process is I will have a discussion with the underwriting team as they're reviewing a policy for renewal and explain what had transpired. We'll have expenses that were paid by Everest, but with the explanation that, we were paying these to potentially save from a larger loss down the line.
I mean, that's really a tremendous advantage for a pre-claim assistance program, because ultimately the dollars that go into defending and or paying on a claim are what are evaluated for purposes of your future premiums. What Everest provides is an opportunity to shortcut by avoiding claims, by incurring a couple of dollars to possibly avoid a much larger issue. And so ultimately, it strikes me that early intervention and prevention can save a boatload of money. And if the carrier is spending a lot less on legal fees, ultimately your premium dollars and the impact on your premiums in the future are bound to benefit substantially.
Yes, certainly agree with that.
Yeah, so I mean, it makes total sense. And if you think about it, it's really logical from the carrier's perspective as well as the client. And just to give you a sense for architects, some people don't recognize that winning at all costs is a win if you win a case, because you could spend years defending a case and spending hundreds of thousands of dollars on legal costs. Or you can settle a case for $10,000, and this goes beyond the pre-claim assistance. And we'll talk about this a little bit more later. But ultimately, the bottom line is, I'd rather settle a case for $10,000 and pay nothing to the lawyer than basically win a case for $300,000. Because ultimately, when a carrier would evaluate the difference, you can well imagine that the $300,000 is going to have a much greater impact than a $10,000 indemnification payment.
Absolutely.
And those are decisions that Stephanie and Everest have to make pretty much every day. Moving along to documentation, and we yeah, thank you. Just to touch on this one more time, this is where documentation in the first instance becomes so critical during the first hint of trouble. So really, we can't emphasize this enough, that the documentation in your file really be maintained in an active way, so that, frankly, if you don't want to help yourself, then help someone like me or Stephanie to try to assist you. So moving along. So, there are times when you're not getting paid, and maybe you're vulnerable, maybe you're not, but maybe you have to make some decisions in terms of how to move forward with the project. And some of those decisions may include suspension or termination of your services. Now, you have to be mindful that you don't want to just do this as a knee-jerk reaction when you don't receive a check, because there could be consequences. Frankly, wrongful termination could create issues that, down the road in terms of delays, because maybe they have to find another architect. The term adjudged in default is a terminology. If you're adjudged in default, that means that judge has to, or no, wrong. So I left in default, and you'll see this in indemnification language as well. And what I mean by working for nothing, what I'm meaning is, well, we spoke, you're going to continue to do work, you're working for nothing. You become a volunteer. So this is a very sensitive area that you should be mindful of. But moving along, and so here's a situation where we have what I call the tripartite relationship. So we really have all three actors to this relationship on this webinar today. We have most of our audience, which are architects. We have the attorney, which that would be me, and we have the insurance company, and that would be Stephanie. And so there is an interrelationship between these three parties during the course of any type of litigation or dispute of some sort. Not all disputes manifest themselves in a lawsuit. Sometimes they can be found in a nasty email or a letter either from the client or from the lawyer, where you know that there is a conflict that requires some type of addressing. So here you have the tripartite relationship. Let's go to the next slide. So the first part of the tripartite relationship that we will address is the role of the insurance company. Let's just go to the next slide. And since we have an insurance professional on this webinar, I'm going to turn this over to Stephanie to address.
Sure. So, like I said in the beginning, I'm the person you do not want to have to deal with. You've purchased this insurance policy and now you have to use it. And unfortunately, that means you have to deal with me. That's okay. I'm accepting of my role here and my career choices. A large part of my role is spending a good amount of time with our insureds explaining how this process will work and what their expectations and involvement will be. For many people, this is their first time dealing with the claim and they just don't have any expectations. They don't know how this will work. So the first thing I explain is, the role of the policy, and in turn my role here, is to ensure that the architect's interests are protected. And that's regardless of their fault or the validity of the claims that are being raised against them. That's why we say Everest has both the duty and the right to defend our insureds. What does that actually mean though? So we speak to our insureds, we gather the facts, we try and build defenses to the claims. More often than not, we assign competent counsel, such as David or others around the country, that use their expertise to help us build defenses to the claims. Also, these claims, more likely than not, will involve the retention of experts in the field who could also opine on whether yourself or your subconsultants met the standard of care. But a key player in the claims process is you. The architect really has the most knowledge about the project. They have the technical expertise about the claims that are now being asserted. While I've certainly learned a lot about design and construction, I in no way proclaim to be an expert. The same way David or I wouldn't take any legal advice from any of you. That's why we need you to provide the records, to remain engaged, to put us in touch with the people who could help us defend the claim. Who was at the project meetings, who completed the drawings. And then either through our meetings or reviewing documents or commenting on the other parties' expert reports, we build our defenses, and that's how we build the claim. Build defenses to the claim and try and either get them dismissed or reach a resolution.
If we could just go back to the prior slide for just a second. So we talked about the roles. There's really the tripartite relationship that I referred to earlier. So you don't just have the role of so Stephanie explained how the insurance company views this relationship. Speaking as the attorney, I work hand in hand with the architect and the insurance company. The insurance company has a lot at stake. It's their fund of money, and I know you paid your premiums, and so you're entitled to rely upon that fund of money. But ultimately, the insurance company has to be mindful of what the risks are associated with the claim. And as the attorney, it's my role to confer with the client. And you've heard Stephanie refer to architects as insureds. From the insurance company's perspective, you're their insureds, and that's an appropriate designation. And so it really is a relationship where all three parties have to work together to address and defend the claim, evaluate the claim, and determine what's best for all involved. And we talked about what the impacts could be from an ultimate resolution versus an ultimate, fight for all costs and fight to the death. When I first started practicing years ago, I had a little bit more hair and it was blonder, not as grayer. And I would go into a client's office, and invariably they would say, I didn't do anything wrong. I don't know why I'm being sued, and I want you to fight to the death, and I'm never going to settle. And that was the common theme. And I understood that. And for me as a young lawyer, to try to say to them, look, this is the first time we're meeting, keep an open mind, you should never rule out settlement. I always concerned myself that they viewed that as a sign of weakness. It wasn't a sign of weakness. It was a sign of recognition of all options that you have to consider. Because ultimately, as I said earlier, if you could spend $10,000 to save $300,000 in legal fees, believe you me, the next time your broker provides you with premium options, the $10,000 is going to be a lot easier to get new premiums that are lower than the $300,000 you spend on Dave Kosikoff. Not that I mind collecting the fees, but my first role is to try to make sure that you as my client takes the best course of action to protect your own interests. So that's my role as the attorney. of course, it is also to defend you. I never went to architectural school, but having handled claims for more than 30 years, there really isn't a claim that I haven't seen before. And if there is, invariably between my client and my experts, I'll get up to speed pretty quickly. So the architect plays an essential role in laying out the issues and helping to define and develop the defense. So believe it or not, even though you have a carrier involved and you have an attorney, your role is really essential. So anyway, moving along today, we're going to go 2 slides now.
David, I did want to make one more point
Right.
on the insurance company's view of claims, right? We certainly understand no one, especially a professional, wants to have claims brought against them, right? Their reputation's at stake. And you certainly don't want to dedicate your time and your money and your resources to having to defend this claim. An initial conversation I usually have with a lot of the insureds is, unfortunately, in America, where we are, it's not that hard for someone to bring a claim against you, right? It doesn't ultimately mean it will be successful, but it still must be defended. And that's why, thankfully, you have insurance, right? And just to touch upon a few of the things that David already mentioned, you know, more than, I would say, 95% of claims are resolved through litigation. Since I've been here, not a single claim has gone to trial. But depending on the complexities of the claim, the number of parties involved, and the jurisdiction where the claim is brought, you know, could take longer to get there than I think our insureds are anticipating, right? And they find that to be very frustrating. One thing I did want to highlight to the, you know, the architects on the line is, you know, you might, once you get a claim in the door, you might talk to some people who have some legal experience and they say, well, can't you get the claim dismissed? These are not the kind of claims that are dismissed early on, unless there is a slam dunk defense, right? You never touched this project. You never did the design for this project. That's not often the case. It's often a case of finger pointing, right? Between various design professionals, between the contractor or the owner. These tend to be multi-party. They also involve what we call, you know, the battle of the experts. David and I both mentioned experts. You know, plaintiff will get an expert to say you didn't meet the standard of care. We'll get an expert to say you did. The courts don't dismiss these. They deem them as factual issues, right? For a jury to determine them later down the line. And that's the next point of rolling the dice. And David touched upon this, so I won't harp on it, but you certainly don't want to spend in excess hundreds of $1,000s defending a claim just to ultimately be successful, right? Because you want to think the long game, your loss runs, right? And of course, defending your reputation. And one last point is, you know, every settlement that's entered into would include a non-admission of liability. Our insureds like that because they want to protect their professional reputation. So I'm sure, David, that's something you would always include in any release when you're making an offer to resolve a claim.
Well, that's right. And to Stephanie's point about trials, so back in the day when I first started practicing and I was trying several cases a year or arbitrating many cases a year, it really is the rare case that goes to trial these days. And one of the reasons why is because when you try to present issues that are so complex to a jury, it's not always easy to do. The jury, depending on your jury, and I used to say the jury are people who are too stupid to figure out how to get off of jury duty. And I stopped saying that when I was selected for jury duty and I couldn't get off of that. But the truth of the matter is that having tried a number of cases, I can tell you that juries have trouble following some of these complicated construction and design issues. And frankly, they have trouble staying awake sometimes because a lot of these cases are not that scintillating when they go to court. So that's one of the reasons why rolling the dice is sometimes dangerous, because if you are going to litigation as opposed to arbitration, we'll talk about that, you know, you run the risk that the trier of fact, the jury, may not understand or may be sympathetic to one party or the other. I'm going to try to get to a couple of the questions. It's going to be hard because we're running a little behind. How does an architect protect themselves from non-compliant existing work? Well, one of the things that you have to be mindful of if you're doing construction administration, that if you note a problem, and you're not always going to find it, but if you note a problem, you have to bring it to the owner's attention and you have to sound the alarm. Because if you don't and you're there, that'll be another area where you'll be blamed. You know, a lot of clients, it's very interesting. I find, particularly when I'm involved in litigation and I'm taking depositions of owners, the owners really believe that the architect is there to protect them from everything under the sun. And that's a dangerous standard that people think that you're there really supervising the case or the project. And that's really not what you're doing. You're going to the site at intervals appropriate to the stage of construction to confirm that the work is generally in accordance with the plans and specifications. That's almost verbatim from the AIA. Well, if you're only there once a week or once every other week, you're not going to catch all the defects. The ones you do catch, you have to say something. That's what's expected of you. But I will tell you that it's probably, it is incumbent upon you to educate your clients, notwithstanding what the contract says, about what it means to do observations so that they know that, you know, the contractor is really responsible for their own work. So that's sort of how that works. There are a couple of other topics mentioned in the chat room, but I'm going to move forward. I'll try to get to your questions at the end. Let's go. So indemnity. So let's just go to the next slide. And let me talk about indemnity for a second. I would say, and Stephanie, I don't know if you've had, in your experience, if you found this, but when it comes to, when I review contracts, the single most common clause that I'm asked to review is the clause involving indemnification. Every client, most clients, particularly clients who have lawyers, try to throw everything at the architect. And it creates a lot of problems. Stephanie, I'm sure when you review contracts, is indemnification the number one on the list?
That is the number one. And I think, and hopefully you're going to educate a lot of the people on the phone, it's because people don't understand what they're being asked to do. And, you know, a lot of times people want to take the work, right? And I get it, but I think it's very important to understand what you're being asked to indemnify.
When I see language in indemnification, what I'm seeing is the architect will hold the owner and the owner's agents and employees and mother and sister and brother and bank and everyone under the sun harmless from any problems that ever arise on a project. Man, that's a really major responsibility. And sometimes they include things that are just not covered by your professional liability policy. For example, they will ask you to assume responsibility for their legal expenses to defend claims. Now, it's not just Everest. I'm pretty sure Everest takes the same view of almost every professional liability carrier that I work for, that contractually mandated defense costs are not covered by your policy. And if that's the case, then by you agreeing to indemnify a client and providing defense costs, you're exposing yourself directly. I don't care if you have insurance or not. The same peril exists when you have what's called a prevailing party clause. So if you have a prevailing party clause, which basically says the winner of a dispute has to pay the loser's legal fees, then you may unwittingly be agreeing to pay defense costs that are also not necessarily covered by your professional liability carrier. So there are things that you should really avoid agreeing if you're going to provide indemnification. And you know, the area where you could provide indemnification, and I'm going to give it a caveat that it really requires careful review, is an area where you'll indemnify for issues that, to the extent they are created by you and you are adjudged to be at fault. And getting back to the word adjudged, which I alluded to earlier, that somebody determines, and not just you or the owner, but a trier of fact, a judge or an arbitrator determines that you're responsible. Those are the expenses that I might expect you to indemnify a client. But you know what? That's why you have professional liability coverage. Because if you do something that you deviate from the accepted standards of practice, that's what your coverage is there for. So in a lot of ways, what I say to my clients is, the owner is better off not compromising your coverage by including issues that are not covered. And that's where you get into a real dicey situation. The other thing that you don't want to have to indemnify someone for is if they've been sued for a claim. You know, people get sued all the time. Someone can trip and fall outside an owner's property and they're going to sue. And if you provide indemnification for claims that are just made, you might be indemnifying an owner for a claim that has nothing to do with you. Maybe they didn't hire a snow removal company. That has nothing to do with you. Or maybe the owner didn't do the appropriate maintenance to fix sidewalks or areas that really have nothing to do with you at all. So when we talk about indemnification, you go to the next slide. You're creating an additional risk that you may not have to. So if you have professional liability coverage, Stephanie, does Everest provide a contract review as part of its policy or have that service available?
We do have that service available, yes.
All right, and that's a valuable service. And is that, Stephanie, one last question, is that included as part of the scope of services that they get for being an insured of Everest?
It is, yes. I do not handle those. They go outside to outside counsel, but we do provide those services to our insured. So if there's questions about what you're being asked to sign, you're working with a new client, or you just want someone to take a look at the contract you've been using to make sure that you're, indemnifying what you should, or you're protected adequately, that's certainly something that we offer to our insureds.
So that's an important service that any of you may want to take advantage of, because the contract language can be really devastating if it's not handled the right way. So we already talked about these items. Unlike insurance, insurance indemnifies you against claims. And what does that mean? Well, so if I walk past your building and you get hit in the head by a brick that falls off the building, you might face a claim, or if I get hit by a brick, you might face a claim by me, and we never met before. So third parties that you may not be in privity of contract with can sue you. You're covered generally for those claims. Indemnification only works against the party you're contracting with, okay? And you have to avoid overbroad indemnification language that could be violative of state law. We're running short for time, so I'm going to kind of move fast. So let's go to the next slide. Okay, third word, ladies and gentlemen, is protection. So make sure you include that. And all right, write that down. It should be in the chat room as well. And then we're going to go to choice of forum. Okay, so when a claim arises, you can face a claim in a couple of different forms. One of the things that I recommend, and the AIA contracts typically have it, is mediation. And then you have also arbitration and a lawsuit, which I'll talk about in a second, because there are a couple of slides later down the road. Let's go to the next slide. And typically what's involved in any type of dispute resolution is documentation. I think we've harped on that topic extensively. And testimony. And that testimony could be during a proceeding or during your deposition, where a court reporter takes down answers to questions that you're posed by counsel. And these are the proof. And we talked about some of the notes that you might take or emails. All that becomes proof. Your drawings become proof. Modifications become proof. Change orders, everything, all that kind of documentation on a project becomes proof that you might see in an arbitration or a litigation. So let's go to the next slide. And this talks about alternative dispute resolution in two forms. I'm going to talk about mediation for a second, then I'm going to turn it over to Stephanie to address her views on mediation and arbitration. So what is mediation? All right, first of all, I am both a mediator and an arbitrator. And in my role as a mediator, so I wouldn't be representing any party to the case. As a mediator, I would hear disputes by adversaries who are trying to address and resolve their claims. The AIA documents typically encourage mediation because since most cases don't go to trial or arbitration, they get resolved early, why not give it a chance to get it resolved early if you can? The amount of savings that you can achieve through an early resolution can be significant. So one of the advantages, aside from timing, it doesn't take that long, is you could have early resolution. It could be a significant savings in costs. It could help you to define the disputed issues, which are not always obvious when you receive a summons and complaint in court. The intermediary, and I mentioned I'm a mediator, but there are plenty of mediators who are just like me, who are either construction lawyers or former judges, or sometimes architects and engineers can be intermediaries, but they're knowledgeable. They're not like the people who are trying to get off a jury or falling asleep. they're people who understand the issues, and they may be able to help the parties to bridge the gap. You might learn something in a mediation that you didn't know about the claim. And one of the other things that I think is important and sometimes overlooked about mediation is, sometimes you have a longstanding client, you get into a dispute, and sometimes you want to try to preserve that relationship. And it might be difficult to do when you have a conflict, but sometimes you could avoid increasing or heightening the conflict by addressing disputes early, and you might actually preserve a relationship and continue to do work for clients. And that's a pretty good reason in itself to try to avoid conflict by mediating claims. And then the next slide, the disadvantages, and I frankly don't think there really are major disadvantages of mediation. There might be a possible additional expense, the time, and you have to pay a mediator. And you may tip your hand if you can't resolve the case. But frankly, there are very few surprises. There are very few moments, like for those of you who maybe watched television shows like Perry Mason, where somehow those lawyers on the TV shows managed to get the witness to admit that they killed somebody, or they find the smoking gun. And frankly, that's just a fiction. That doesn't happen very often. I like to say that the worst thing that ever happened to lawyers who actually are practicing law is the proliferation of lawyer television shows. Because what happens is that in less than an hour, somehow the lawyer who presents the case has this sterling opening, and the cross-examination, they have a witness sobbing. They always win the case. And if you don't count commercials, they've always also managed to have some type of a romantic interlude in 42 minutes of television. And that a case takes years, and it doesn't happen that way. So I laugh when I see television shows about lawyers, because there's such a fiction, and yet that's what a lot of people know. Cases take a long time to get resolved. So don't listen to television. Anyway, Stephanie, between mediation and arbitration, I know you wanted to speak about this.
Yeah, so, mediation is my preference. I attend many mediations, especially over the past year. I've seen a huge uptick in mediations because people, both sides of the V, as we like to say, the claimants and the defendants, are realizing that to go through court with all the delays and the backlog is going to take years and years. So it's worthwhile, like you referenced, David, to try and get an earlier resolution, get in front of a mediator, see if we could talk through the issues. Multiple jurisdictions actually mandate mediation. It's a prerequisite before you can continue going forward. You have to appear for some kind of mediation. And David touched upon this, but my number one rule is to always select a mediator with experience of design and construction. We don't want to have to spend a lot of time wasting our time educating this mediator on what they need to know, or risk having them make a poor recommendation because they just don't understand the parties' roles and responsibilities on the project. So that's why I always look for folks who have either design or construction or a combination of both, and they know what they're talking about, right? That I don't really see a lot of drawbacks to mediation, and yes, it is time, it's commitment, it is a cost, but if you don't like what's going on, if you can't reach a resolution, you walk away, you tried, right? As opposed to arbitration, and this is why arbitrations are not really favored, it's permanent, right? It's a final judgment and you can't appeal from it, unlike when you go to court, the rare cases that are decided at trial, as David referenced. I have noticed an increase in parties wanting to go to arbitration over the past year or so. I think that's because they think that they could just use the mandatory mediation ahead of the arbitration to try and resolve the case. And that's most often what happens. Another downside to arbitration is, you're not being judged by a jury or peers. You're decided by one or multiple arbitrators who may not know anything about this industry. There are certain situations where we have voluntarily agreed to arbitration. That's been a unique cases where the owner and the contractor are going to arbitration, and we don't want to be in a position where they reach a resolution and they reach agreements by pointing the finger at us, and we're not there to defend ourselves. So we actually have voluntarily participated. That being said, my overall philosophy will remain litigation with the voluntary mediation, because that's where we have the most results. I would say about 90% of the claims resolve at mediation.
It's interesting, Stephanie. I've seen a change, and you and several carriers are against or don't favor arbitration. And you can see the list of disadvantages on this slide here. Arbitration does have, frankly, I could go either way because arbitrations have advantages and disadvantages. I'll address the disadvantages first because Stephanie's not wrong. Arbitrations present certain problems in terms of you not being able to appeal a decision. Sometimes you get a rogue arbitrator who's looking for just to split the baby. Arbitrators are not bound by the rules of evidence. There's no joinder of third parties sometimes. The AIA contracts sometimes preclude joinder of third parties. And so the feeling among many is that arbitrations or arbitrators look to split the baby, and that doesn't really justify, or it's not justified if you're just looking to try to throw up your hands and make everybody happy. You can't make everybody happy. So I'm mindful of Stephanie's view that Everest is not necessarily, not that you would preclude it if a client wanted to or contracted themselves to, but there are concerns about arbitration, and what Stephanie said is fair. Let's just go back to the prior, and here are some of the advantages, but they have to be balanced. Timing, they tend to go faster. Cost, I guess I used to think that arbitrations were less expensive because you save on a lot of litigation expenses such as depositions and court conferences and motion practice. But the truth is that one thing that you have to do in arbitration is pay the arbitrator. So cost is probably more or less of a wash. A major advantage of arbitration is that the judge of the facts is more knowledgeable. Again, a retired judge, a construction lawyer, someone who knows knows the industry, and the reduced discovery is an advantage. And there's one other advantage, and this has to do with probably more mediation than arbitration, but that has to do with your time. And what do I mean by that? Well, if you're going to be forced to participate in a claim, then ultimately you're going to have to take the time out of your busy day and your profitable day to spend time preparing and gathering documents and meeting with your lawyer. So that's not even on this slide or the next slide. That has to do with the ultimate impact to your practice, and the emotional one as well, of facing a claim that you can resolve early. Probably another advantage to mediation. So Stephanie's not wrong. I mean, there really is there's been a shift away from arbitrations by many carriers who perceive, for the very reasons that Stephanie pointed out, that arbitration can have its problems. To me, I would say it depends on the claim, but that doesn't necessarily help if you're negotiating an arbitration clause in your contract. I personally like arbitration, but I'm just as mindful and sensitive to carriers' views that arbitration has some disadvantages. And frankly, to me, it's almost a jump ball at this point. Moving along, let's go to the next slide, and then the next slide after that. I'm going to breeze through this subject because we are running short of time. It's amazing how much time you can talk and you don't even realize it. Go to the next slide if you would. So copyright is something that these are the instruments of service that really belong to the author, which typically is the architect. And some of the things that you'll see is that owners would love to have the ownership. I don't encourage that because the design elements of instruments of service really belong to you. And you don't want to get into a problem where if you use similar design elements on another project, you're going to be accused of violating an owner's copyright if you give the owner the rights to the instruments of service. What I would endorse, and what the AIA documents endorse, is giving the owner a limited license for use for their project, provided that they pay for that license. And if they don't pay, then I'd say, too bad, they don't get that. The other thing that you should be mindful of, and it's really not part of the slide, but I want you to be aware of it. There are times when you'll find that an owner wants to hire you in the middle of a job, all right? And what you should be thoughtful about is a couple of things. One is, why is it the middle of the job and they're replacing their architect? Could that be an issue with the architect? Could that be an issue with the owner? You might want to ask questions. You might even want to talk about the architect. You talk to the architect that you're being asked to replace. But the other thing you should be sensitive to is if an owner is asking you to get involved in a project Well, maybe that other architect has the copyright interests in those drawings. And even if the owner says, don't worry about it, you do have to worry about it because you could be on the firing line for a claim of copyright infringement. I've seen it. I've had to defend against it. So you want some level of satisfaction that if you are being asked to and you decide to replace the prior architect, that you understand the reasons behind it and that you make sure that you don't face off on an issue of copyright infringement. So I would encourage you to do that. And the other thing I talk about here, limit owners' rights to use your design. Well, you don't want the owner to have the right to use your design and take it to do 47 other projects. That doesn't seem fair. So you want to limit their use to your project. And if they're going to make any changes, you want to be indemnified for that. Because very often they do make changes and you don't want to be blamed for design issues. Let's go on to the next slide. And sometimes, you could always register your designs with the US Copyright Office and get a copyright notice. The other thing we encourage you to do, and I'm not saying do that for every project, it'd be very expensive, but if you start to think that something's going south, you may want to do that to protect your interests. What would be the advantage of a copyright issue? And that is, an advantage would be that you can, you get statutory damages for use of if you have a copyright notice. And that's important because it's a federal statute, copyright, and you may have the ability to get legal fees in a copyright dispute because statutorily you're entitled to them, but only if you have the appropriate copyright registration. Otherwise, you should put that C on your drawing because that's an important indication to your client that they're on notice that you're the owner of the copyright. Stephanie, I think you may have had an issue about the limited use and the selling of a project having to do with copyright.
Right. So, it's tangentially related to the copyright, but more about the use of the design by the ultimate owner here, right? We have a claim, the insured completed a project back in the early 2000s. The client was a developer. The project got shelved. Didn't have the funding to complete the project. Then, we're in an economic downturn in the early 2000s. It was a large-scale residential multi-unit development. At the return of the construction boom in, around 2010, another developer picks up this project and unbeknownst to our insured also transfers the design documents. This project then starts getting built. The insured's never contacted or consulted. We fast forward to 2020, the project's partially completed and there are allegedly some issues arising, and the new developer is now raising some allegations of negligence and improper design against our insured. We're developing the fact, and it appears that the subsequent development was not the same as the original development. So here we have a developer working off documents prepared for, an original project when they've changed the scope. There are defenses here. We're exploring them, including a change of scope, and also there's some procedural statute of limitations arguments, but we're right where we don't want to be, defending this claim brought by someone that the insured did not contract to do business with. And this could have been avoided by the inclusion of, the limitation of use provision and non-allowance of transfer of the insured's design to a subsequent project owner. So, I can't stress that enough. That's something you can consult with David or of course other attorneys, make sure the party that you're giving the design documents to, they can't then turn around and give them to someone else. So I think that's an important part to make.
No, that's an excellent point, Stephanie. We're running really short, so I'm going to race through these last couple of slides. I'm sorry. And it talks about termination. Let's go to, proceed. Termination and suspension. So time period measured by aggregate number of calendar days as opposed to consecutive days. That's an issue you might want to address in your contract. You don't want to have no responsibility for delay due to non-payment. So if you're not getting paid and the project is lagging on, you don't want to be hit for responsibility for that. You want to include the right to suspend and terminate in your agreement. Not that you're going to employ that right, but if you don't even include it in your contract, there's a real chance that you don't have the right assert claim, the right to suspend or terminate. And adjustment of fees to completion date. One of the things that I've seen more and more of is that projects get delayed. And ultimately, you have to be sensitive about what the additional cost is for you. You should put in a timetable in terms of the number of months you expect to complete design and construction, because if you run over that, you should note that as an additional service. So forgive me, I'm racing through because I see we have 3 minutes. I'll try to answer your questions at the end. Let's go to the next slide. Procedures for termination of services. Now, I have to say, if you're going to make a decision to terminate services, you have to think very carefully before doing it, because it's going to have an impact on the job. For example, you may, as the design professional, be required to sign off on a project. Well, if you terminate your services, this is going to delay the ultimate sign off while the owner has to hire a new architect. So you better be sure you're right. Because if you're not, there are consequences. One of the things, if you have a conflict and you want to get out, and maybe the owner wants you out too, maybe you'd be better off if you have the ability to work with the owner to walk away, jointly. Then maybe you may have to give up something for that, but having peace at the end of the project without the potential for a claim is something that you might be able to avoid. If you have a document, a contract that talks about what your entitlements are for including expenses incurred and lost profit, that would be ideal if you can include that in your agreement. Look, I can't emphasize this enough. Going back to the very earliest slide that talks about the ability to, during the honeymoon period, that's the time to negotiate the provisions that really might be of great sensitivity. Like we talked about mediation and arbitration and indemnification. I mean, these are all provisions that are really the doomsday scenario where if things go wrong. So it's really, and I don't want to call this like a prenuptial agreement, but that's the time when the areas of sensitivity, what do you do when you get into a fight? That's the time to negotiate those items. The right to terminate, the right to suspend. Those are the types of issues that the best time to do it is when you are in your honeymoon period and everybody's getting along, so you don't have to worry about having a conflict. Let's go to the next slide. So look, we've covered a lot in this presentation. By no means did we cover everything. We couldn't have possibly, but hopefully we've given you enough information that gives you food for thought. And if you run into a scenario, you have professionals, you have Stephanie and her carrier, Everest, which really is one of the top carriers around. And somebody had asked earlier about my contact information. And I believe that they are on both Stephanie's and mine are on the earliest slide. This is, here's my contact information. For those of you who are looking for the standard form of agreement that I alluded to earlier, you can feel free to ask. It's yours for the taking. I'm happy to share it with you. And finally, and this is your fourth word, so make sure you write it down. Your fourth CE word is arbitration. So please make sure to write that down. Ladies and gentlemen, we are at the midnight hour. I would like to thank Stephanie for her participation and for her generosity in sponsoring this event. I'd like to thank the group at AIA New York State, who does a great job of putting these presentations together, and for giving me and Stephanie the opportunity to present to you. And we invite you to reach out to us directly if you have any further questions. But with that, we will say our goodbyes and hope to see you in the next presentation. So thank you, everyone. We really appreciate it.
Yes, thank you, everyone. Take care.